Ladies and gentlemen, welcome back to a brand new legal breaking reporting and video analysis update. One mystery: what the Supreme Court plans to do to America in this upcoming term. Let's get onto this reporting by VOX. Ladies and gentlemen, the article is titled One Mystery and Two Looming Disasters in the Next Supreme Court Term. What the Supreme Court plans to do to America in its upcoming term. Ladies and gentlemen, the article reads, the reissues dominate the Supreme Court term that begins next week. Based on the cases the justices have agreed to hear so far. Realistically, however, there is little uncertainty about how this GOP-dominated court will resolve two of them. The uncertain question is whether the court will strike down President Donald Trump's shifting tariffs, a question the justices will ladies and gentlemen, will take up in November. The tariffs are clearly illegal under a doctrine the Republican justices used to halt many of Joe Biden's policies, and many leading conservatives are vocal opponents of the tariffs, some of whom are even involved in this case. But the court's Republican majority rarely breaks with Trump. There's less mystery about how the court will handle two other groups of cases which concern election law and LGBTQ plus issues. The Supreme Court Justice ladies and gentlemen, Elena Kagan wrote in a 2021 dissenting opinion, quote, has treated no statute worse, unquote, than the Voting Rights Act. The landmark 1965 law that banned race discrimination in elections. Kagan's Republican colleagues repealed central provisions of the law and misread other provisions of the law so ladies and gentlemen, graciously, that it is hard to believe they are acting in good faith. In its upcoming term, the Republican justices are widely expected to expand on its project. Ladies and gentlemen, this project. abolishing the Voting Rights Act's long-standing safeguards against racial discrimination, racial gerrymandering, which is highly illegal, ladies and gentlemen. And they are expected to do so at the very moment that President Donald Trump is pushing Republican lawmakers to gerrymander their states to lock the Democratic Party out of power. Before we continue, ladies and gentlemen, with this reporting by Vox, Donald Trump wants to do that. Well, then on the next election, in the next election, in 4 years after 2028, he's in for one hell of a beating. If he so plans to illegally try to gerrymander. Racially, that is. He deserves to not even be in office, even a third term. He deserves to rot in prison, right in Rikers Island, where they are already waiting for him. Judging from the possible 34, from the what was supposed to be his trial to be sentenced to prison time instead of the bullshit honorable discharge or whatever, or conditional discharge or whatever he was sentenced to. Continuing with the reporting, ladies and gentlemen. The court is also likely to advance another of the Republican justices' longstanding projects. Ladies and gentlemen, I almost said powers. Projects destroying campaign finance regulation. One of the few campaign finance laws that even most Republican judges have historically supported is a cap on donations to individual candidates during the 2026 election. For example, congressional candidates may only accept up to $3,500 from each individual donation to their primary election campaign and another $3,500 for their general election campaign. In National Republican Senatorial Committee v. FBC, however, the Republican justices are likely to open up a loophole that would effectively allow donors to give tens, ladies and gentlemen, of thousands of dollars to individual candidates, thus increasing wealthy donors' ability to trade money for favors. The other big loser in the upcoming term is likely to be queer people. The court seems poised to strike down bans on ladies and gentlemen, conversion therapy, where therapists try to suppress their patients' sexual orientation or gender identity. It's also likely to uphold state laws requiring student athletes to play on a sex-segregated team that aligns with their sex assigned at birth. Many of the biggest cases of the upcoming term, moreover, are yet to be determined. The court announces which cases it will hear during its October to April argument session. Ladies and gentlemen, sessions on a rolling basis, typically finalizing the full list during the winter. Last term, the court handed down a long string of temporary decisions, handing significant victories to Donald Trump, including a decision permitting him to fire many federal employees, that many federal programs cease to function. Several of these cases are likely to return to the court in 2026. So we will find out soon if the justices intend to permanently endorse many of Trump's illegal, my editorials note, aggressive attempts to remake Americans, ladies and gentlemen, American society. Ladies and gentlemen, the tariffs cases, Trump v. VOS selections, and learning resources v. Trump. If you've paid attention to U.S. economic policy or business news these past several months, ladies and gentlemen, like I have, my editorials note, you're already familiar with the tariffs cases. Trump has imposed very high and frequently changing taxes on goods imported to the United States. Many federal judges have determined that these tariffs are illegal. The justices will decide in the upcoming term of the Supreme Court. Ladies and gentlemen, my editorials note, whether they agree. Trump claims that the tariffs are permitted under a federal law, the International Emergency Economic Powers Act of 1977, IEEPA, which enables the president to regulate transactions involving any property in which any foreign country or a national thereof has any interest. IEEPA, however, only permits the president to use this power to deal with an unusual and extraordinary threat. On that note, ladies and gentlemen, there is currently no unusual or extraordinary threat to the United States. The plaintiffs challenging the tariffs raise several statutory arguments against them. Among other things, they argue that the power to regulate imports does not include the power to tax them. They also argue that Trump hasn't identified any unusual and extraordinary threat that can justify the tariffs. The president points to trade deficits with other nations. Those have been commonplace since 1970s. Since the 1970s. Additionally, the Republican justices frequently struck down Biden-era policies that, in their words, involved questions of vast economic and political significance. Trump's tariffs have enormous economic and political significance. So if the court's Republicans intend to apply the same rules to Trump that they did to Biden, they must strike the tariffs down. Ladies and gentlemen, it's springtime for gerrymandering. Louisiana v. Calais. In 2023, the Supreme Court shocked pretty much everyone who follows election law when it upheld a lower court decision requiring Alabama to redraw its congressional maps to include an additional black majority district. As Chief Justice John Roberts wrote in Allen v. Milligan, the lower court's decision holding that Alabama's original maps violate the Voting Rights Act faithfully, and I quote, ladies and gentlemen, applied our president's precedents, unquote. But the Republican justices had shown such unrelenting hostility to the Voting Rights Act that the court's decision to honor those precedents, again, ladies and gentlemen, precedents, was shocking. Now, however, it appears that Milligan was a one-off decision, and the court's decision in that case was likely due to bad lawyering by Alabama's attorneys. On October 15, the court will hear oral arguments in Louisiana v. Calais, a case that is virtually identical to Milligan, and the justices asked for a special briefing on whether the Voting Rights Act's anti-gerrymandering safeguards violate the Constitution. So it's not hard to guess how this case will turn out. A decision abolishing those safeguards is likely to devastate black representation in red states, where voting is racially polarized, meaning that black people overwhelmingly vote for Democrats, while white voters similarly favor Republicans. I'm a white voter and I do not favor Republicans whatsoever, especially with what they're doing in this present time with my American country. It's also likely to supercharge Trump's efforts to gerrymander Congress to lock the GOP into power, because it will remove a barrier that Republican lawmakers had to overcome in order to draw partisan gerrymanderers. Ladies and gentlemen, it's winter for campaign finance regulation. National Republican Senatorial Committee (VFEC), in their infamous decision in Citizens United (VFEC) 2010, the Republican justices held that corporations may spend unlimited amounts of money to influence U.S. elections. That led to a proliferate proliferation of entities such as PACs that can spend millions of dollars on behalf of a partisan candidate. Ladies and gentlemen, particular candidate, but which are at least normally nominally distinct from that candidate's campaign. In theory, super PACs are not supposed to coordinate their spending or messaging with their candidates they support. Which, ladies and gentlemen, is exactly what Elon Musk's PAC did with Donald Trump. This means that Elon Musk is in a hell of a lot of trouble. Direct donations to candidates, by contrast, are still capped in the 2026 election cycle. Congressional candidates may raise no more than $7,000 per donor. Political parties, meanwhile, may accept donations subject to a higher cap. Party candidates committees like the Republican State Leadership Committee or the Democratic Congressional Campaign Committee, for example, may accept donations of up to $44,300 per year. Federal law prohibits these party groups from coordinating with individual candidates to determine how these larger donations are spent. as the Supreme Court warned in Buckley's, ladies and gentlemen, Buckley v. Valeo in 1976, expenditures controlled by or coordinated with the candidate and his campaign might well have virtually the same value to the candidate as a contribution and would pose similar dangers of abuse. If the DCCC, for example, can accept a $40,000 donation from a donor who wants to use that money to elect Joe Smith to Congress, and if the DCCC can work with Smith's campaign to determine how that money is spent, then the law might as well allow donors to give $40,000 directly to Smith's campaign. In National Republican Senatorial Committee, the GOP asks the court to tear down this prohibition on coordinated expenditures and effectively permit wealthy donors to give tens of thousands of dollars directly to candidates. Given the Republican justices' hostility to campaign finance laws, it is likely that Republicans will get what they want. Ladies and gentlemen, the transports cases Little v. Hickox and West Virginia v. BPJ. Much of transgender politics over the past several years have focused on the issues at the heart of Little and BPJ. Many states have laws that prohibit trans student athletes from playing on sports teams that align with their gender identity. The Supreme Court is going to decide whether those laws violate their either the Constitution or a federal ban on sex discrimination in education. Realistically, these laws would be tough cases for the trans community to win, even if the court were not dominated by conservative Republicans. In Bostock v. Clayton County, which was a case in 2020, the court held that a federal law prohibiting sex discrimination by employers forbids anti-trans discrimination in the workplace. The court reasoned that if an employer intentionally penalizes a person identified as a male at birth for traits or actions that it tolerates in an employee identified as female at birth, then it is treating workers differently based on their sex. But the Bostock framework does not apply to sports because sports teams are one of the few areas where U.S. law generally tolerates sex segregation. Sex discrimination is inherent in the very concept of a men's or women's sports team. So, trans advocates cannot challenge exclusionary policies simply by pointing out that they engage in sex discrimination. And, of course, the court is dominated by conservative Republicans who, in United States v. Scrimity, which is a case that they heard in 2025 of this year, recently held that states may prohibit minors from receiving gender-affirming care. Excuse me, ladies and gentlemen, healthcare, that is. So, trans advocates face a difficult uphill climb in Little and BPJ. Ladies and gentlemen, conversion therapy, Childs v. Salazar. About half of U.S. states have laws restricting conversion therapy. Discredited method of counseling that attempts to turn LGBTQ plus patients cisgender, CIS, gender, ladies and gentlemen, or heterosexual. The Colorado law at issue is Childs. Excuse me, ladies and gentlemen, in Childs, for example, bars conversion therapy for patients under age 18, though it also exempts counselors who are engaged in the practice of religious symmetry. Excuse me, ladies and gentlemen, ministry. As one federal appeals court explained, every major medical, psychiatric, psychological, and professional mental health organization opposes the use of conversion therapy. The American Psychological Association, for example, says that it puts individuals at a significant risk of harm and is not effective in changing a person's gender identity or sexual orientation. That said, Childs does raise a difficult First Amendment question. On the one hand, it's not hard to imagine how a law prohibiting some forms of talk therapy implicates the constitutional guarantee of free speech. On the other hand, the law has historically permitted states to regulate professional misconduct, even if that misconduct involves speech. A lawyer may be disbarred for telling a client that it is legal to rob banks, and a physician can be charged with murder if they tell a patient to drink a jug of arsenic. Will those examples be enough to persuade this court? Excuse me, ladies and gentlemen, the Supreme Court, that the Colorado law is a regulation of professional misconduct and not an attack on free speech, unlikely. But the justices will at least need to wrestle with how to distinguish speech by a lawyer or doctor from speech by a therapist. Ladies and gentlemen, executing people with an intellectual disability, Ham v. Smith. Nearly a quarter of a century ago, in Atkins v. Virginia in 2002, a coalition of Democratic and moderate Republican justices held that offenders with an intellectual disability, intellectual may not be sentenced to death. They reasoned that these individuals have diminished mental capacity, at least as compared to non-disabled adults, and thus bear less moral responsibility for homicide crimes. Another decision 3 years later applied the same logic to juvenile offenders. Both decisions were met with mockery and derision from the court's right flank. And that right flank now controls the Supreme Court. So the question in Ham v. Smith is just how far these justices will go to roll back decisions like Atkins. The death row inmate at the heart of Smith, Joseph Clifton Smith, took several IQ tests where he scored slightly above 70. Courts often look at whether an inmate's IQ score is below 70 when determining if they are intellectually disabled, though the Supreme Court has held that other factors can support a finding that Smith has an intellectual disability. Nevertheless, if a majority of the justices want to decide Smith narrowly, they could simply rule that borderline cases such as Smith do not fall within Atkins and that Smith may be executed. A second possibility is that the court could overrule Atkins, thus permitting people who unquestionably are intellectually disabled to be killed by the state. And then there's a third possibility. Writing for the Republican justices in Buckley, Bucklew v. Persith, Persith. I believe I'm pronouncing that correctly. Which is a case that they heard in 2019. Justice Neil Gorsuch seemed to suggest that the past 6 decades of Supreme Court decisions interpreting the Constitution's ban on cruel and unusual punishments should be tossed out, and that courts should simply ask whether a particular form of punishment was considered too cruel in 1989. If Gorsuch gets his way, that would be a catastrophic event for all criminal defendants. Among other things, ladies and gentlemen, Gorsuch's approach would likely eliminate any constitutional concerns about disproportionate punishments. So someone could potentially get the death penalty for shoplifting or life in prison for jaywalking. That, to me, honestly, ladies and gentlemen, honestly is a bunch of bullshit, and hopefully does not occur. It's also theoretically possible that the Supreme Court will agree with a lower court that held that Smith may not be executed. But given the Republican Party's broad support for the death penalty, that outcome seems unlikely. Unfortunately, in my editorials note, ladies and gentlemen, arbitrarily tossing out ballots. Bost v. Illinois State Board of Elections. The specific legal issue before the court in Boston is, fairly low stakes. The court will decide if the plaintiffs in this case candidates for federal office are permitted to bring a lawsuit seeking to toss out many ballots in states that permit voting by mail. Even if these plaintiffs prevail in the Supreme Court, though, that will only give them an opportunity to pursue their ladies and gentlemen, entirely ridiculous legal challenge in lower courts. The case is worth watching, however, because 3 of the Trumpiest judges in the country handed down a decision last year claiming that it is illegal for states to count mailed-in ballots that are mailed before Election Day, but that arrive afterward. The 3 Fifth Circuit judges opinion, in that case known as Republican National Committee v. Wetzel, claims that an 1872 law setting the date for federal elections also prohibits states from counting ballots that arrive after the date, and somehow no one noticed this fact for the previous 152 years. In any event, the Fifth Circuit routinely hands down decisions that are too outlandish even for this Supreme Court, and ladies and gentlemen, it is likely that the justices will eventually reverse the decision in Wetzel, depending on what the court says in Bost. That decision may wind up shutting down Wetzel as well. The cases listed above are drawn excessively from the matter. Ladies and gentlemen, the matters. The justices have already agreed to hear their merits docket. They will undoubtedly be joined by several more blockbuster cases, including multiple challenges to Trump's mass firings, attempt to cancel federal spending, and his aggressive use of federal law enforcement. Even without these additional cases, however, the 2025-26 term is already shaping up to be extraordinarily consequential